Discovery should be provided.
Don't play word games with me.
I'm not playing.
Mr. Allen, not play word games with me. You're playing with the wrong judge.
I'm not trying.
I'm giving you your warning.
I would like to first have a jurisdiction hearing.
So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it.
This court hearing quickly becomes heated as a sovereign citizen repeatedly challenges the judge and appears to test the court's patience. The situation grows more intense as the exchange continues, and it soon becomes clear that pushing the judge's limits is not going to work out in his favor. For those unfamiliar with the concept, sovereign citizens often argue that they can reject or stand outside certain laws, claiming they are not subject to the same legal authority as everyone else. The back and forth between the defendant and the judge creates a tense and unusual courtroom
which the trust
that many viewers find both surprising and fascinating to watch. As the hearing unfolds, the atmosphere grows more dramatic, making it one of those courtroom exchanges that keeps people watching to see how it will end. Let us know what you think about this hearing, and if you enjoy following courtroom moments like this, be sure to stay tuned for more.
A day here.
Already, Judge Judgeoakley, Assistant Public Defender, on behalf of Mr. Day.
He's there. Can you turn on your camera, sir?
I don't have any contract with a public defender's office.
You what?
I don't have any contract with the public defender's office to represent me.
You don't have a contract with them?
Correct.
Yes, Judge. I reached out to Mr. Day to try to help pre-try this case.
Is this going to be a Bellinger's thing?
I think so, Judge.
Okay, go for it.
My understanding is that he had enough counsel that he's going to have, I believe, on his file. And I wish him good luck if that's the case, but I don't see another attorney here. So I don't know what's going on, Your Honor.
No.
Mr. Day?
I'm defending myself. I told him that I would notify the court that I relieved him of any implied obligations to this case.
So you're going to represent yourself?
I'm defending myself, correct.
Okay, then you need to be here. Now.
Well, as I told the court, I requested a Zoom hearing because I have COVID. So there's no way I can.
In a vehicle with a hat on, no mask. Oh,
I am inside my vehicle right now.
What'd you say?
I said yes, because I'm inside my vehicle right now. I work outside. I'm away from the general public.
Did you go to the hospital regarding the COVID diagnosis?
Excuse me?
Have you been to the doctor regarding the COVID diagnosis?
It's against my religion.
Okay, so here's what you're going to do. Then I'm going to say, okay, you've got COVID. I want you here. When's our last block? 3 o'clock today. Wear a mask if you're going to represent yourself.
I can't make that. Is there a later date?
Oh, yeah, you can. 3 o'clock.
3:30, I can make that.
I'll be here at 3 o'clock.
Well, I'll be there at 3:30, and if there's any issue, then
okay. And at 3 o'clock, I may issue a bench warrant. Be here at 3 o'clock. I'll pass this matter. Thank you.
There's no bench warrant to be issued because this court didn't have.
Okay, I'll determine that at 3 o'clock.
The court
See
didn't
you at
have.
3 o'clock. Thank you.
This court does not have jurisdiction.
You're welcome, Mr. Feaster. Cut his line.
It turns out the situation becomes even more awkward when the timeline of his arrival comes up. He had claimed that he would arrive at 3:30. But records showed he actually appeared at 3 o'clock, which raises questions about why the statement didn't match the facts. Moments like this tend to draw the judge's attention because accuracy and honesty are extremely important during court proceedings. When the court believes someone has been misleading or untruthful, it can create additional problems for that person in the legal system. Giving false or misleading information to the court can lead to serious consequences, sometimes even being treated as contempt of court, depending on the circumstances. Beyond that, Behavior that appears dishonest can also make a judge less willing to give the
Just for
benefit
the
of the
record, I
doubt
put it on the
later in
record
the
that I
hearing.
object.
Instead of helping
Under
his
threat, duress, and
position,
coercion.
the situation
Again,
makes
your
it seem like
objection
he
is
is
noted.
wasting the
Right, and under
court's
threat,
time
duress, and
and not
coercion,
taking the process seriously. Because of that,
I'll be here.
the strategy of arguing while also making statements that
there
appear
anything
inconsistent
else?
rarely works in someone's favor.
I said
Courtrooms
what I need to
operate
say.
on rules and procedures, and when those are
Anything else from
ignored,
the people?
the outcome usually becomes
No, Your
much
Honor.
more
Thank you.
difficult for the person involved. Many viewers watching the hearing are left questioning whether this
Bond will
approach was
continue.
really a
Am I
smart
waiting for
decision
paperwork or
or if
get
it
it from the
only
front?
made the situation worse.
Am I waiting for? Yes.
All right, you understand at your arraignment, you were given the charges that were filed, have been filed against you?
I was given a charge. So if there were any additional, I was not given those charges. The only charge I got was a fleeing and eluding,
Fleeing and eluding third degree.
third degree, correct. And if anything else was tallied onto that, then I was not told.
Okay. I have one charge.
Okay.
That is a felony punishable by up to 5 years incarceration and $1,000 fine plus court costs. The Secretary of State would be required upon your conviction to suspend your license for a period of 1 year. You understand that, sir?
First, I wanted like an oral motion for dismissal based on the fact of the lack of probable cause and also the lack of a personal and subject matter jurisdiction based on the fact that this is a trust matter from the name to the private conveyance that was stolen by the third party Wall Street Towing and impounded on the colorful law actions of Officer Trowbridge of the Washtenaw County Sheriff's Department. Also, I have not been able to, as of Constitution Amendment 6, being able to face my accuser. With the state of Michigan being a fictitious entity and there's no injured party, there's no crime that has been committed. And again, to the probable cause of the initial stop and the arrest cannot be proven. There was no probable cause for the arrest or stop. There was no warrant on hand for the arresting officer to conduct an arrest. And even more so, again, as I stated, this is trust property, so this court doesn't have the
It can be difficult to understand the reasoning behind the arguments this man is making. First, he appears to give inconsistent information to the judge, and then he walks into the courtroom insisting that the court has no jurisdiction over him. He also argues that the case should be dismissed because there is no injured party
held and protected within the trust.
Statements like these are commonly heard in sovereign citizen
Article 1,
style
Section 10,
arguments,
Clause 2
but
of
they
the United
usually
States
don't
Constitution.
align with how the
There could be
legal
no
system
legislative
actually
laws
works that in reality. Courts generally
could
do have
intercede or to
jurisdiction over
interrupt
cases that
the
occur
functioning
within their
of a
authority,
contract, which
especially
the trust
when
is
someone has
and
been
is
brought before
properly,
the court for a specific charge.
and
The
the
claim
trust
that a
is
case
properly
must involve
functioning
an
at this
injured
time.
party is
So,
also a
with
misunderstanding
that,
because
All right, so
many
here's what we'll
offenses,
do,
such as
because
fleeing
you're
or
rambling
attempting
again.
to evade law enforcement,
So what
can
we
still
will
be
do
prosecuted
is you
even
will
if no
put all of your
individual victim is
jurisdictional
directly
arguments in
involved.
writing.
Because of that, the discussion ends up
Because you're
feeling more
wrong.
like a debate over
So we might as
personal
well get it in
interpretations
writing
of
that
the
you're
law
wrong.
rather than a structured legal
Because I
defense.
have subject
As the
matter
hearing
jurisdiction
continues,
over you,
it becomes
and I
clear
have
that
personal
repeating these
jurisdiction
claims
over
is
you
not helping his
under the
situation,
Constitution
and
of
the
the United
courtroom
States
exchange
and the
only grows
Constitution of
more
the State of
tense
Michigan.
as the judge continues addressing the arguments being presented.
Oh, no, actually, I was also moving to place you and the clerk as fiduciaries over the trust. And I'll be able to supply you all with the adequate assurance certificate of security to settle and offset the charges.
Okay. Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. As to your other motion regarding all of that, quite frankly, it doesn't make any sense. We haven't even had the probable cause hearing. There will be a determination at the next stage as to whether or not there's probable cause regarding the charges.
I was told this was a probable cause hearing,
This is a probable cause hearing.
so I don't understand what you're saying.
I know you don't understand.
They're not having a probable cause.
Pardon?
You said that no probable cause was had, but then you said that this is a probable cause hearing.
You have not had your preliminary examination, at which there will be a determination as to whether or not there's probable cause to believe that the crime has been committed and you committed it. That is the next stage. That has not happened. So to the extent that your motion is even valid, which I do not believe that it is, and certainly you may raise it at a later date, but to the extent that it's valid, at least at this point, your motion is premature, and therefore your motion is denied. Anything else?
Well, lastly, I want to also put on the record, I wasn't able to provide all my exhibits based on, as I told you, I was.
You weren't able to do what?
Provide my exhibits.
To whom?
To the court to help for my defense, the evidences.
You haven't had a hearing yet.
I comprehend it. I'm just saying that I usually have my documents precede me before any hearings take place, and I wasn't able to because I was under the weather. That was my point. So they will be here, if not by the end of the day in the drop-off box, and you'll have them tomorrow. But you all will be served with the proper documents, and the taxes as well will be filed on the case.
Okay. Anything else?
No, not at this time.
All right. So how would you like to proceed next on this?
Entering a plea of demurrer.
Okay, you've already done.
As the hearing continues, it becomes clear that the judge is growing increasingly frustrated with the arguments being presented. Again. The exchange starts to feel uncomfortable for some viewers because the defendant appears to be struggling to keep up with the legal process, while the judge firmly challenges his claims. Judge Simpson seems particularly tired of hearing the same types of arguments often associated with sovereign citizen theories, and that frustration shows in the way the discussion unfolds in the same time. The defendant appears to believe he is participating in a more detailed legal debate, possibly expecting the hearing to work differently than it actually does. His insistence on certain procedural points, like demanding specific evidence at that stage, suggests that he may misunderstand how the process works. This disconnect between what he expects and how the court operates is part of what makes the situation so difficult to watch. Many observers also question why he chose not to accept legal representation,
so for right now, as of this
especially
moment,
when free legal aid is often available. Having a lawyer can help explain the process and present arguments in a way that aligns with court procedures. Instead, by continuing to argue on his own without a clear legal strategy, the situation becomes increasingly tense as the judge moves forward with the hearing.
Is it possible to get... I've already entered a plea of demurrer. I'm not sure when that took place other than right now.
That took place on the arraignment on the complaint, sir.
I never pleaded demurrer.
You stood mute, you stood demurrer. You don't even know what that means. You're just using words and have no concept as to what they mean.
Demurrer and mute are two separate things, but that's neither here nor there.
No, they're not. You have no legal degree. They are not. They are not. They are not.
I'm not here.
They are virtually the same thing. So where do you wish to proceed now?
As I stated, my motion.
Do you wish this set for preliminary examination? Your motions have been denied.
I wish for the prosecution to provide the evidence that any of this needs.
You don't have discovery on this case. Is that what you're asking?
I'm not asking for discovery whatsoever.
So what are you asking for?
I stated that the prosecution needs to prove that a crime was committed, and they also need to show and prove that there is an injured party for the crime to have even been committed.
As I've indicated, you will have that hearing. Do you wish to have discovery?
Discovery should be provided regardless. There's no wish about it.
Do you wish to have discovery?
Should be provided.
Don't play word games with me.
I'm not playing.
Mr. Allen.
Discovery.
Not play word games with me. You're playing with the wrong judge. You can smile and smirk all you want.
I'm not trying.
I'm giving you your warning. I will ask you again. Do you wish to have discovery provided to you?
Yes.
Sir, did you wish to then have another PCC, or did you wish to proceed immediately to preliminary examination?
I would like to first have a jurisdiction hearing,
What kind of jurisdiction here?
personal and subject matter.
Okay. Go ahead and raise it because I can deal with it right now. What's the personal jurisdiction?
As the hearing continues, the man asks for what he calls a jurisdiction hearing, which leaves many observers confused about his strategy. A jurisdiction hearing is meant to address whether a court has the authority to hear a particular case, and those issues are usually raised at the very beginning of legal proceedings.
25th.
If someone truly believes a court lacks authority over their case, that argument is typically presented early in the process rather than after the case is already underway that I end the situation. The court has already scheduled the hearing and the defendant has appeared before the judge, which generally indicates that the court recognizes its authority to handle the matter. Because of that, asking for a jurisdiction challenge at this stage doesn't appear likely to change the direction of the case. Moments like this often lead viewers to wonder where the defendant is getting his legal information or advice, especially when the arguments being presented do not align with how courtroom procedures usually work. The exchange highlights how misunderstandings about legal processes can make a situation even more complicated for someone representing themselves. Instead of helping his position, repeating these arguments may simply prolong the hearing while the judge continues moving forward with the case.
I said what I need to say. The state lacks personal jurisdiction. I'm simply here under threat and duress of coercion of you saying that you would hope put out a bench warrant for my arrest. The subject matter in regards to the name as well as the vessel that was used is again under it was conveyed and is held and protected within the trust. And according to Article 1, Section 10, Clause 2 of the United States Constitution, there could be no legislative laws that could intercede or to interrupt the functioning of a contract, which the trust is and is properly properly functioning at this time. So with that.
All right. So here's what we'll do, because you're rambling again. So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong, because I have subject matter jurisdiction over you and I have personal jurisdiction over you under the Constitution of the United States and the Constitution of the State of Michigan. So if you want to put your objections to jurisdiction in writing, you may do so, and then I will address those in due course.
Awesome. So that would be the next step, and I can get those in today.
No, that is not the next step. Either you're going to have another PCC. If you want me to set it for a hearing, I'll set it for a hearing.
Yeah, for the jurisdiction.
But I have nothing to set a hearing on. You have not filed anything regarding jurisdiction.
Okay, so for right now, as of this moment, PCC is fine, and then I will file the proper documents for the jurisdictional hearing. Gotcha.
So I'll adjourn the probable cause conference in this case, April 25th, 2024 at 3 p.m.
Is it possible to get another week for
person
to provide to accumulate my documents for my defense?
Is there what?
Is it possible to have that extended out another week so that I can provide my?
I'm going to set it 25th.
I mean, I was on the call. I've heard you give multiple counsels extended times. So what is the bias?
I have no bias against you, sir.
Well, I'm simply asking for
I'm
a reasonable
setting the date
so
of 2 weeks out. You can have your motion together, file your motion. I will be able to address your motion at that time so that we can get this headed to a PCC, to a preliminary examination.
Just for the record, I'll put it on the record that I object. But under threat, duress, or coercion, again.
Your objection is noted.
Right. And under threat and duress and coercion, I'll be here.
Is there anything else?
I said what I need to say.
Anything else from the people?
No, Your Honor. Thank you.
Bond will continue.
Am I waiting for paperwork or get it from the front?
Pardon?
Am I waiting for paperwork regarding the next?
No, you may leave.
Oh, is it being mailed? Or I'm trying to figure out how to get the paper.
You can check out at the front counter.
Okay.
As the hearing comes to an end, it raises an interesting question about whether the judge's response was too harsh or simply necessary given the situation. Some viewers might feel that the judge's tone seemed strict or impatient, while others may see it as a reasonable reaction to someone repeatedly challenging the court without presenting a clear legal argument. From that perspective, the judge's response can be seen as a firm reminder that the courtroom is not a place for games or unsupported claims. The defendant appeared to enter the hearing expecting to challenge the process using arguments often associated with sovereign citizen beliefs. However, those types of claims rarely succeed in court, and judges frequently respond by explaining the legal reality in direct terms. Moments like this sometimes serve as a wake-up call, encouraging people to approach legal matters more seriously and consider getting proper legal representation. Having an attorney can help someone understand the procedures, present arguments correctly, and avoid making the situation more difficult than it needs to be. The situation also reflects a broader discussion about how these types of arguments have become more visible online in recent years. Some people are influenced by misleading information or conspiracy theories that claim there are loopholes allowing individuals to ignore laws or court authority. In practice, those ideas almost never hold up in real legal proceedings, which is why these courtroom exchanges can become so tense and drawn out that in the end, the judge appeared to focus on maintaining order in the courtroom while addressing the defendant's claims directly. For many viewers, the case becomes less about the specific charges and more about how the legal system responds when someone refuses to accept the basic rules of the court. It's the kind of situation that naturally sparks debate. Some people believe the judge handled it perfectly, while others think a different approach may.